Okay, this is Jennifer Bivens with the Georgia Network to End Sexual Assault. We want to thank everyone who has joined the webinar. This is the webinar regarding the labor law changes, and we are very fortunate to be able to partner with Pro Bono Partnership of Atlanta. And we have two attorneys that they are going to introduce themselves, but it's Valerie Barney and Whitney Farrar. Was that right? Okay. Who are going to be doing the webinar today. And again, we thank you very much for participating. And we know that this was a need that you said that you were very interested in learning more about and help that you needed. So this is the opportunity to do that. If you are not able to stay through the whole webinar, we are recording it. So you will be able to access this later. But again, thank you for joining us. And I'm going to turn it over to Valerie and Laurie. Thank you. Whitney, sorry.
Thank you so much, Jennifer. And Valerie's going to step over here. I will introduce myself. My name is Whitney Ferrer, and I'm a partner with the law firm of Littler Mendelson. And I specialize primarily in wage and hour law and compliance with federal wage and hour laws. So that's what we're going to be talking about today. And we also have Valerie Barney here.
Hi, my name is Valerie Barney, and I am in-house, so I work directly for a company. I work for Mohawk Industries Incorporated, who's based in Calhoun, Georgia, and I handle pretty much everything that happens in the employment world. So I handle wage and hour issues, but I also handle, and I may have a little bit of a different viewpoint than Whitney. So that's the good thing about this morning is that each of us has a different viewpoint on these subjects. So we'll both be talking through, and then you'll have an opportunity to ask questions through the chat, and we're going to go through the presentation, and then we're going to address those questions at the end. But please enter the questions as we go through so those get captured.
Absolutely. And just a couple of brief moments to talk a little bit about Pro Bono Atlanta, who is sponsoring obviously this seminar this morning. And just a brief mention, you've got the mission of Pro Bono Partnership there in your materials, but it is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. And you also have in your materials the criteria by which you can become a client of Pro Bono Partnership of Atlanta. And you have that there in terms of if you're interested in becoming a client. And then what would be a legal seminar with lawyers without a legal disclaimer? So we want to just remind you that this morning that this is educational. We're going to be providing you with overview of the law, and it will be very practical information for you to use, but please know for your individual specific questions, we do advise you to consult with a lawyer because in many times, in order to really give you the true advice, we need to know the specifics. So again, please treat this for educational purposes. And so we're going to go ahead and get started. So we have a lot of material to cover this morning. We're going to briefly talk about the changes in the regulations that are becoming effective December 1st, 2016. And I think a lot of you participating this morning know about that, but we're going to go through that briefly. Then we're going to talk about generally the requirements for how you treat or how you classify employees as exempt from overtime or non-exempt. So we want to take you through that. And then we know for non-exempt employees, so employees that get overtime if they work over 40 hours in a week, there are a lot of specific rules. There's just lots of rules out there. And so we're going to talk specifically about your questions. I know we've received questions about, how do we record time for on-call? How do we record time for other activities? So we're also going to spend some time talking about those specific rules as well. So we will go ahead and we'll get started. So fortunately, we are in Georgia, and the state of Georgia follows the Fair Labor Standards Act, which is the federal law that's been on the books for a long time. It's been on the books since 1938. So it's an old law, and it's not really a very easy law to understand because it's so old, and it was really put in place to deal with child labor laws and basically situations going on in the Great Depression. And so fast forward, and we obviously have a much different workforce today. So one of my colleagues fondly refers to the FLSA as the forever lost in seeking answers, because that's really how a lot of us view it, because it's a confusing law. But the basics of the law, this is the law that sets forth minimum wage requirements, and it is the law that sets forth the basic overtime requirements. And as I said, we're in the state of Georgia, and so we're lucky. We only really have to worry about compliance with this federal law. There are not a lot of state variations. In fact, we don't have a separate state law, so we really are only concerned about federal law. And so that's what we're going to be talking about today. And basically that law sets forth, if in fact you have an employee who is non-exempt, so they don't qualify for any of the exceptions to the rule, and that's what we're going to spend time talking about today, is the exceptions. But if they are non-exempt, if they work over 40 hours in a week, they get overtime. And basically that's time and a half. So if they're paid at an hourly wage, that's time and a half for any hours they work over 40. So what we've heard about in terms of the rule change, I had mentioned that there are exceptions, or what we call exemptions. And so within the Fair Labor Standards Act, there are basically, they're called the white collar exemptions. There are about 6 of them. The ones we're going to talk about today are, number 1, the executive, and this is the exemption that refers to your managers. So your folks that have direct reports reporting up to them, that's called the executive. Then we have the administrative exemption, which is probably the worst named exemption ever, because it doesn't really apply to your administrative folks. It basically applies to your folks that are doing work in furtherance of the business, but they're not executives. They're not actually managing people. They're more managing functional areas, and they're being decision makers in various aspects of the business. And so we'll talk a little bit more about that. Then you have professionals, which in our work, that typically refers to registered nurses, other healthcare providers, in terms of the professional exemption. And then we have a couple others that we're not really going to spend too much time talking about today, because they're not necessarily impacted by the rule change. So the big rule change that we have that's going into effect on December 1st, 2016, is the fact that the Department of Labor has decided that basically everybody needs to get a pay raise. So part of the rule for the exemption is that there's been a salary basis threshold, that in order to qualify for an exemption, you have to pay your exempt employees a certain amount of money. And that has been just over $23,000, which works out to $455 a week. And it's been raised over the years in varying amounts, but since 2004, that has been what the salary basis has been. Now, the Department of Labor has basically doubled that. So they are now saying that effective December 1st, if in fact you are still going to have employees that are classified as exempt, they are going to have a pay raise, and they're going to have to go up to $913 per week, which just comes out to just over $47,000. So that is a huge spike. It's almost doubling. And so I know that's what's causing a lot of concern. Obviously, with our centers, that's a lot of money. And so that's what we're going to be talking about today. And I want to pause just for a moment and get Valerie's take in terms of, from a practical standpoint, from her experience with her employees, how is that bump? How have you all been handling that?
Well, so if you look at your range of employees, there are some people who make over, and there are some people who make under, and you have to make the decision, are you going to move people over in order to avoid overtime? And one preliminary point of this is, if somebody is part-time and they're working less than 40 hours a week, then this doesn't really matter, because you're paying them straight time. So this is really all about the people who work more than 40 hours in a week. So if you have part-timers, you can set them aside, take them off your worry list. You need to be tracking their time to make sure they don't work over 40 hours a week. But then if you look at the people who truly do work over 40 hours a week, you have to make the decision, are you going to bump them over the 47,476, or are you going to move them to overtime eligible or non-exempt? and most employers are doing some of both. So a lot of the things that we'll talk about for the people who are moving to non-exempt, about tracking their time, that's when, once you make that decision, that's when all of those things really apply. And that is a change for a lot of people. And one thing that you should know is you are not in this alone. Employers everywhere are having to make these decisions. There's a lot of big companies and a lot of small companies that are really struggling with these decisions. And so it is a game changer. When you called it a spike, that is a great description. It is a game changer for how we think about how we pay people.
Absolutely, absolutely, and everybody is struggling with it, small and big companies as well. A couple other little nuances with the rule that I'll just mention in case you've heard about them and have questions. There is a part of the rule now that if in fact you pay commissions or if you pay bonuses, you can count up to 10% of that going toward the annual salary. There's some conditions around that. You can't wait to pay the bonus at the end of the year, as a lot of employers do. In fact, you have to pay that out on a quarterly basis. So even though the Department of Labor has sort of extended that carrot, if you will, as a way to sort of mitigate, in practice, it's very difficult for employers to actually utilize that if in fact they're typically paying out on an annual bonus basis. But that is part of it. And then the other piece of it that's really not getting a lot of discussion right now because it's really far in the future, but they also have basically embedded within the rule an automatic salary increase every 3 years. So even though we're scrambling to become into compliance this year, we're going to have to redo this exercise in 3 years. Now, I will say there's a little bit of breaking news. The other day, there were 2 lawsuits filed in a district court in Texas. One was filed, I think it's 23 states, including the state of Georgia. The attorney generals of those states have filed a lawsuit basically seeking an injunction to stop the law from going into effect December 1st. And in addition, the Chamber of Commerce, in addition with local chambers, has also filed a lawsuit. Actually, that's been filed by my law firm, Wilmer Mendelsohn. So there are in fact, two lawsuits going right now to basically get an injunction. It is not necessarily clear cut. Those are difficult lawsuits, so we're not entirely sure what the outcome will be. So we are basically advising employers to keep an eye on those lawsuits, but still to continue preparations to come into compliance December 1st, because the outcome of those lawsuits is in fact uncertain. But that is a new development, and it'll be interesting to see what happens with regard to those lawsuits. So we're going to shift gears a little bit now, and we're going to talk about the actual job duties of the exemptions. And we're doing this because, practically speaking, we know that doubling the salaries of the exempt employees for most positions is going to be very difficult. But in fact, if there is budget, or if there are reasons to raise salaries up to meet that threshold, that's not the end of the story. The salary threshold is just basically that. It's the threshold. So you have to hit that salary to basically be in the ballpark of making the argument. There are still very specific job duties requirements for exemptions that you also have to meet. So we're going to talk about those a little as well, because I think it's very easy to think, oh, well, we are raising the salaries, we're fine, we've got exempt employees if we're paying them this $47,476. And unfortunately, that's not the end of the story. We still have these additional requirements. So as I had mentioned, the first exemption that we typically talk about is the managerial exemption. It's called the executive exemption. And basically, that is a position that has a primary duty of management. So if it's an entire organization, so an entire center, or if it's a subdivision within an organization. So, for example, this may not be the situation here, but for example, a company might have a finance and accounting department, and they may have a director over that department, but then they also may have subunits within that department. So they may have an accounting part of it. They may have an accounts payable part. And so you can have managers all over all of those different subdivisions, and they can still qualify for the executive exemption. The second piece of the exemption is that these managers have to have 2 or more full-time direct reports. And the Department of Labor defines full-time direct reports as 40 hours a week. So basically that's 80 hours. So we have part-time employees. You basically have to add it up, so you have 80 hours. So for example, you might have four part-time employees reporting to you. You can add them up for purposes of getting to the 2 full-time direct reports. I know I've seen questions about contractors. Contractors don't count toward the executive exemption. So if you have contractors, you can't count them as employees for purposes of the executive exemption. So that's number 1. That's your executive exemption. The other exemption that we have that I mentioned was the administrative. The primary duty of the administrative exemption is that the employee in this position must have a primary duty of doing office work, so it doesn't relate to manual workers. And when we think about the FLSA being passed in 1938, that was the factory workers. It was the people on the factory floor. It's the technicians. It's the people that are doing that manual labor with their hands. This exemption does not apply to them. This applies, as I said, to that director of finance or the accounting department, the people that are doing more of the back-end office work. That is what that exemption is meant to apply to. The second piece of it, and this is a legal term of art that you will hear, but it doesn't make a lot of sense. The primary duty must involve the exercise of discretion and independent judgment on matters of significance. And the regulations provide very specific examples of what that means. But for me to boil it down for you, basically that means the employee in that role qualifying for that exemption must have the authority to either make decisions or make recommendations on decisions of significance for the business.
So that would be your program director who is making decisions about the services that you're going to provide, or working with your executive director to make those decisions. In this world, there is no one anymore, it seems like, who gets to make the final decision all by themselves. And so, but the law recognizes that as long as that person is making recommendations and working with their manager to make these decisions. So it's different than the person who is a true support person who is doing what someone directs them to do. And an example that I use for this one is you think about the difference between a secretary and the Secretary of the Navy. You know, that is the old word for secretary of the corporation, administrator of a government function. That's what those words used to mean in 1938. They didn't mean, oh, I'll ask my admin to do that, which is what it means now. So it's a different kind of viewpoint of those words.
Yeah, that's a great point, Valerie. And also, again, why I had said the administrative exemption is so badly named, you would think it actually applies to those people that are doing the administrative support work, all of that important support work, and it actually doesn't. The regulations talk about the fact that routine bookkeeping, routine clerical work, repetitive work, that actually does not qualify because that doesn't require the exercise of discretion. And so the Department of Labor views that as following very set processes to do repetitive or routine work. And so that's where we run into challenges as employers in terms of figuring out what that means for the administrative exemption. The third exemption, as I mentioned, was the professional. And there's 2 parts of the professional exemption. The learn and professional is basically, that applies to folks who have a primary duty that has been work requiring advanced knowledge. So basically an advanced degree. And it has to be a very specialized knowledge. So we had mentioned in healthcare, obviously a doctor would qualify for the learn and professional. But nurses, registered nurses, RNs, who have gone through very specific nursing, who are certified nurses, those types of nurses also can meet the professional. And the flip side, your clinical nurses do not, because they have not gone through that set of certifications and requirements. So when you all are looking within your organizations in terms of your advocates, in terms of your nurses, that is something to be aware of in terms of the professional. You want to make sure, if you have nurses within your centers that you want to keep as exempt and you're thinking about bumping up their salaries, you want to make sure that you're still, meeting those professional requirements. Because if they don't have those certifications, there's really no reason to bump up their salaries, because you're going to have a challenge meeting the learned professional in any event. So those are the basic the 3 exemptions that we're talking about for purposes of this rule change. There is a computer professional. I didn't see necessarily any job titles for your organization, so I'm not going to talk about that as well. But that would be another possible exemption. So just in terms of what you all need to do for next steps, we've really already sort of touched on it in terms of what Valerie said. Obviously, you need to take a look at your salaries for your employees, figure out who might be below, and then just basically make the determination, is there money to bump them up? And then also look at it in terms of what we've discussed, in terms of the duties requirements that you would need to meet in order to continue classifying them as exempt. If in fact you do have positions that you think you're going to have to reclassify, and realistically, we assume that that is the case. Quite frankly, I don't think that there are any companies or any employers in America that are not contemplating making some changes. It's just a reality. When you more than double the salary basis threshold, it's just a reality. So what do you need to do when you've made that decision? Okay, I can no longer classify this person as exempt. They're going to now be eligible for overtime. The first thing you're going to want to think about is, how am I going to pay them? They have currently been paid on a salary basis. You can continue to pay them on a salary basis, but they have to record their overtime. They have to record their hours worked. And if in fact they work over 40 hours, you still need to pay them the time and a half. So that is one way. The easiest way, quite frankly, from an administrative standpoint, is to pay them hourly. Because if you're just paying them hourly and you're not paying them any other compensation, and we'll talk about that in a minute, if they're getting payment for on-call time, if they're getting any sort of bonus, there are additional calculations and additional considerations, because you basically have to include that in. But at the simplest level, if you convert them from salary to hourly, you just have to pay them time and a half that hourly rate if they go over 40. And then I think also equally important, it may not necessarily be feasible, but you're going to want to think about, how can you control the overtime costs? Is there a way to cap them at the 40 hours? And that is definitely something that you as an employer can do. You have to be careful if there are circumstances in which they do need to go over 40. You do need to pay them overtime. But there are ways you might want to think about managing them to a 40-hour work week.
One other reason too, so we've looked at the kind of the downside, right, of this whole law. If you convert people to an hourly basis, when people are, and there's, we use the terms exempt and non-exempt because that's what's in the law. And out in the real world, people tend to say hourly and salaried. And that's a little bit confusing, because people who are exempt have to be salaried, but you can be salaried and still be eligible for overtime. But if you convert people to an hourly basis, then there is, from a management standpoint, there are positives to that too, because if someone is exempt, then there are rules about docking their pay. If they don't show up one day, you're not allowed to necessarily dock their pay without getting into trouble. I'll just call it that. That's a whole section of the wage and hour issue. But if somebody is hourly and they don't come in, then you don't have to pay them, and so you can take the upside and the downside, and that is a real value for moving people over to hourly. then you're not having to to worry about attendance and sick pay and those kinds of things, because it's pretty clear when people work and you only have to pay them when they show up.
Yes, absolutely. That is a great point, Valerie. And I think something really to think about, depending on how many employees you do have, that you might have to convert to hourly or non-exempt in any event. Some employers also are managing the change, and this may or may not be options for the centers, by hiring additional employees to just, share the workloads that you don't have as many people working overtime. And then the use of volunteers or independent contractors, and we'll talk specifically about contractors a little bit later. The other piece as an employer you need to think about in terms of this conversion is what types of policies do you need to put in place, or what types of policies do you need to extend that you already have in place for your non-exempt workers, and extend them to these people who are now being converted to non-exempt status. And we're, of course, going to talk a little bit more in depth about this in a couple minutes when we talk about pay rules. But generally speaking, we need to start thinking about policies about off-the-clock work. So, time that they typically would spend as exempt employees, maybe checking their emails after work, we don't have to worry about that for exempt employees. But now that we have them as non-exempt employees, we have to make sure that they're capturing that time. And so we're going to talk about meal and rest breaks, travel time, mobile device policies, etc. So I'm going to sort of table that slide for a minute. We're going to talk more in detail about that in terms of policies. And then last but not least, obviously, we need to communicate the change. If, in fact, we're going to become into compliance on December 1st, we need to start looking at when we need to put that change in place for payroll. So most employers, I think, Valerie, you mentioned you all are actually targeting an earlier date than December 1st. But there's a lot of work that goes into that plan. Do you want to talk a little bit about that?
We have we picked an October 1st date because we have open enrollment in the fall, and because of some things internally, it made sense for us to push the date back. But then again, we have a large number of employees, and so there's a lot more process to work through. And we do have the kind of organization that Whitney described, where you have multiple layers, and anytime you have multiple layers, there's a lot more processes and people who have to be worked through. But it's on the one side it is more complicated, but on the other side it is the exact same decisions that you all will be making, looking at people individual by individual, looking at their job, and then looking at their pay and making that decision about each one. And that's just what we went through.
Yep, absolutely. And in terms of the communication message, obviously, share with your employees, the law has changed. And so because of budgetary reasons, if in fact that's the case, there just is not money to raise them, explain that to them. A lot of employees have read the news. There's been a lot of press about this. And so they'll be aware, and just be very frank and say, this is what has happened. It doesn't mean that you're any less valued. Your work is just as important to us. But unfortunately, if the case is that there's not budget to pay for it, they need to understand that it's quite frankly out of our control. It's just out of your control. And I've been signaled to talk a little louder, so I will attempt to do that. Yes. Yes. There we go.
Okay.
All right. So now we're going to talk a little bit about the rules that apply to the non-exempt folks once they're classified as non-exempt. So some pay basics. I mean, essentially, you've got some slides in here that talk about what is work. For your purposes, once you have employees that are classified as eligible for overtime, from an employer perspective, it is the responsibility of the employer to make sure that that employee is accurately reporting all their time, or so essentially that you have accurate records of the time that they're worked. Now, it is a two-way street. Obviously, employees have to understand the obligation, and they have to understand that they, in fact, are required to now clock in or clock out. And let's talk about that a little bit.
What does that look like in a small organization? notation.
Exactly.
Yeah.
So the FLSA, again, I said they're not really great at being clear in terms of how they define things. But generally speaking, under the FLSA, the workday starts when that employee starts um, their principal work activity. So, for example, once they roll into work, um, if they get their cup of coffee and they go around and say hello, that's not necessarily work. But when they sit down, they boot up their computer, they start responding to emails, that in fact is the start of their workday. And so for non-exempt employees, they have to notate that that is in fact when their workday has started. And so there's different ways that you can record that. There are electric timekeeping systems. A lot of employers have web-based systems where they can go onto their computer and a website and they can clock in or they can clock out. Or they can write on an electronic timesheet, okay, I'm starting work at 9:05 a.m. But whatever the case may be, it may be a manual timesheet.
It could be a piece of paper.
Exactly.
There is nothing in the law that says you've got to do anything fancy at all. It could be a piece of paper.
Exactly. But the end of the day, they have to be recording it, and you as the employer have to have that record to show that in fact this is when they worked and they've made that notation. And so that is just the general what is work. A couple of other ideas, and this has become, in the last probably 10 or 15 years or so, there have been a lot of lawsuits challenging this called off-the-clock work. And so there's a lot of theories out there, but essentially, if you know that your employee is doing the work and you are not doing anything to stop them from doing the work, you have to pay them. So for example, if you have a program director who you know after hours is going home and is responding to emails, and you know that they're doing that because you're in fact getting the email, you know that they're working. And so in fact, you need to make sure that those newly converted to non-exempt status people know that either they can't respond to those emails at night or they have to record that time.
Yeah, so from a philosophical basis, if you read some of the press about the change in this law, the point is either to pay people for the time that they work, or else the quality of life, work-life balance issue. And so that's really the spin that's been put on this law, that people should not be working all the hours of the day and night and not getting fair pay for it. So if you think about it in that kind of mindset, this makes a little more sense. But there's also the de minimis rule, right? If someone checks an email periodically or answers a phone call periodically, then that doesn't need to be tracked and paid. But the question is really, at what point does it become so much that it does need to be paid?
Right, exactly. And so generally speaking, because this is one of the areas where the law runs into practicality.
That's right. That's right.
And so to Valerie's point, a stray email every once in a while that's not recorded, that's not going to be the end of the world. But the question is, on a daily basis, what's the policy that you're going to be communicating? And do you need to think about putting a policy in place that basically says you can or you cannot do it, but if you are doing it, you need to record your time. Okay, so we're going to flip through a little bit. I don't know if you all are following on your slides. We're actually going to be jumping up to the slide that's called meal and rest break. This is a very specific issue. So the law basically says that if you give an employee a 30-minute time to take a lunch or to take a meal break, and it's uninterrupted, so they have that 30 minutes on their own to run out to do errands, whatever the case may be. If that is their time and they're not interrupted, they don't have a supervisor coming in and saying, can you please file this? They're not responding to emails, they're not taking phone calls. As long as they're not interrupted, they don't have to be paid for that time. And so a lot of employees do have, in fact, a 30-minute meal break or an hour meal break, depending on their schedules. And that's fine. The challenge challenge for employers that are converting exempt to non-exempt is exempt employees they're used to not having to worry about that. So if they're sitting at their desk eating their sandwich and they get an email in, they'll respond to the email and it doesn't matter. They don't have to record that time. So I think for employers, this is going to be one of the areas that's going to be the hardest in terms of educating your folks about how to comply with this. Because essentially, if they're used to sitting at their desk and multitasking and doing a bunch of different things, that's where we're going to need to have a change. And so a lot of employers will in fact require them to get away from their desk, will require them to go to a break room, may require them to clock out. But if in fact something does come up, there's an emergency that comes in, there's a call that comes in, they need to know that they need to record that time, because essentially that becomes work time. So I'll pause here because Valerie, I'm guessing that's probably an area that you see a lot of questions on.
And one of the things is, if you allow people to work through their lunches, you can allow people to work through their lunches, that's fine. You just have to pay them for working through their lunch. You can't call it a meal, a meal period or a lunch period and then not relieve them from their duties. So that is a change. And one of the things that many companies require and we require is for people to write down the time that they took their lunch break. It is very convenient to have the person record their time either via email to their boss or something like that, however you're doing it, and then say, oh, and I took a half an hour lunch. So that seems easy, but the difficulty is it's sloppy. And it is much better if you actually record the time that you left and you record the time that the person came back, and then you know how long it is. And then on the other side of that, it also protects you from abuse, where somebody said, oh, I took 30 minutes, but the person who is answering the phone when that person is not there will say, no, they were gone an hour. No, they were gone an hour and a half. I don't know how long they were gone, but it was a really long time. So that way, if you get in the practice and you have that habit of having people record in and out, then it solves a whole lot of problems. And if you establish that at the beginning, then you don't have to have those really difficult conversations with people when they are abusing things, because that's just the practice. It's not about them at that point.
Exactly. That's very good advice.
What about breaks? When do you have to pay for breaks?
Yes. So breaks, this is the other piece of the meal and rest breaks. So for breaks, as I had mentioned, 30 minutes is fine not to pay them. FLSA is a little bit gray in terms of what happens between 20 and 30 minutes. But what we do know is that a break that is 20 minutes or less does need to be paid. And so it's customary, I think, in industry to allow folks to have 2 breaks. So typically you'll have a break in the morning and you'll have a break in the afternoon, and that usually might be between 15 and 20 minutes. When they get those breaks, that has to be paid time. The only time that you don't have to pay is when it's 30 minutes. As I said, it's a little bit gray between 20 and 30. So if you've got specific questions about that, I would, reach out to a lawyer. But for your purposes, breaks of 15 to 20 minutes, you still have to pay them for that time.
But you don't have to give them a break. There's nothing under federal law that says you have to give them a lunch, although you probably should at least allow people to eat if you want any kind of quality of work. But you don't have to give them breaks. Many years ago, I had people tell me that they had a constitutional right to take a smoke break. That is not true. So you don't have to do that. So whatever your workplace is, what the environment is, whatever you decide, that's fine. That's not a right that people have.
Absolutely. And especially in Georgia, there are some states where there's a state law, but not in Georgia.
Not in Georgia.
Okay, so another big area that's going to be a challenge for employers with this is the issue of on-call time. And I know specifically for our particular audience that there is on-call time. And so essentially what the law talks about is engaged to be waiting or waiting to be engaged. So essentially what we think about is when you have an employee who's on call, do they have control over their time? And if they have control over their time, they're basically waiting to be engaged. So they may be at home, they may be able to basically have control over doing what they want, but it may be that they get a phone call or they get an email and they have to report to work. Once they actually report to work, that then becomes work time. And they, of course, have to record that time and they have to be paid for that time. And if, in fact, those on-call duties take them over 40 hours in a work week, they would need to be paid time and a half. One just sort of practical note with that, you can, within one work week, so overtime is calculated for a work week, so depending on how you define that, if it's Monday through Sunday, or however you define it, you can work within that work week to offset the impact of on-call. So for example, if you've got an employee who's on call Monday through Wednesday, and they end up, I don't know, working, 35, 36 hours, and if they continue on that path through the end of the work week, it's going to put them over 40, you can give them time off in that week so that they don't hit the 40. What you can't do is split that between work weeks. So you can't play fast and loose with that definition of a work week. You can only control it within that work week. And a lot of employers pay bi-weekly, right? So they'll have a pay period that's 2 weeks. And so where I can see them sometimes getting tripped up is that they think that they can balance that time between the 2 work weeks because it's a pay period. And you can't do that. You still have to do it within the work week. But that can be a very practical way for you all to balance your on-call time. As if you're trending over 40, maybe give them that Friday afternoon off so that you're not bumping them over 40. So to get back to that general concept, if they have control over the time that they can still do their own activities, you don't have to pay them for the time that they're on call. However, if they're engaged to be waiting, if in fact they are at a center and they're waiting for somebody to come in, or they're at a medical facility and they really don't have control over their time because they're basically there waiting for something to happen, that then becomes compensable work time. And basically the law for that is you do have to pay them at least minimum wage. So there are other ways, and this gets a little more complicated if you're paying 2 different rates, but what the law requires is for that time you have to pay them at least minimum wage. So sometimes employers may have different rates of pay. An on-call rate may be less than what their normal rate would be. Now that does create some challenges for calculating the overtime because there's a weighted average. You kind of have to add up all the rates of pay, and that's going to impact their eventual overtime, and I'm not going to get into the math for that. But that is one way to try to offset the cost of some of the on-call time, is to pay a different rate for the on-call time.
So if you have someone who is at home, who is doing their laundry and packing lunches for tomorrow, and they get a call, and let's say the call is the work, right? They get a call and they have to call somebody and deal with a problem. Then that the period of time at which they're dealing with the call is the time that needs to be paid because they had the ability to do things while they were at home. So let's take that example and make it a little different. Let's say the person's at home, they're doing laundry and they're packing lunches, but they know that they could be called, and they have to be able to be wherever at the hospital within 30 minutes. They get a call, they drive to the hospital. At what point does the work start?
Well, that's a very good question because there can be travel time issues as well in terms of whether or not that travel time needs to be compensated. But if it's typically, and this is really getting into the weeds in terms of what counts for travel time, a typical commute into work does not actually have to be paid unless it's an excessive amount of time. In that situation, however, I would say if they're having to go back and forth within that on-call period, if there's multiple trips going back and forth between the hospital, that probably is going to flip that travel time because essentially that's starting the continuous day. So basically the answer to that question is it's really going to depend on the circumstances. But that's a great segue, and we can talk a little bit about travel time. And that's looking forward a second, but I'll jump back and talk about training time. So in terms of travel time, as I said, the actual commuting into work, so going to your place of business, that does not need to be paid for. There can be some situations, if it's an excessive commute, an employer is requiring you to go to a different location, that may be situations in which that's compensable, but for the most time you don't have to worry about that travel time. However, if you are in a situation where an employee has to report to different locations within the day, so for example, if they're having to travel to different hospitals, or perhaps they're having to travel to meet somebody at their home, or what have you, basically all of that travel falls within the workday. And so that would all become compensable time. And so that may be something that may be a little bit different for you as well. Depending if you've got employees that you're paying more on a piece rate basis, for example, in terms of visits, that can be where sometimes you need to think about whether that travel during the day needs to be compensated and reported as hours worked. There also are very specific rules that talk about when you have to pay employees for example, if they're traveling to a different city for one day of work in a different city. There are very specific rates for, in fact, if you have to travel and go out of town for overnight travel. And I won't get into the details there. And that would be something, if you've got that situation, I would definitely recommend to reach out to an attorney because there are very specific issues with regard to that. The bottom line is you don't actually have to pay them if it's outside their normal work schedule. And that rule is a little bit strange, but in fact, that is one of the rules.
And that's something we'd recommend if you are moving people to hourly pay who are going to travel or who are going to go to different locations. That's something you would want to develop a policy and then follow your policy, because in the area of wage and hour is very important to have written policies that you can point to. It helps both from the employee relations aspect where somebody's saying, why do I have to do this? But it also helps if there is some kind of issue and you can say, well, this is our policy and we followed it, and then maybe we made a mistake one time, but generally we follow this. That really helps you under the law. And also you can do your research and understand in your particular situation what should be paid and what doesn't need to be paid. Because the difficulty with wage and hour is a lot of times you all are looking for a really specific answer that's really definitive, and the lawyer is going to say it depends, because things really do depend on the facts of a particular situation. And that is where you can come up with your policy based on your particular facts, and that's very helpful. And then you know what you're supposed to be doing because it's written down.
Absolutely. And that's just a great practice in any event to have a policy, because then that's going to ensure that you're treating different employees consistently. And it also provides you with protection, because when you're going to a situation where you now have people who have been exempt to non-exempt, there's going to be, this is a cultural change. They're going to have to get used to something. And if you have it in a policy, you can refer to the policy and say, this is now our policy. This is what we have to comply with, especially maybe for the meal and rest breaks. Well, why can't I sit at my computer and eat my sandwich and respond to emails? Well, because this is now the policy that you have to have uninterrupted meal break. So that will provide you, I think, with some guidelines in terms of how you're educating and dealing with your non-exempt workforce as well. Some other issues in terms of rules that apply specifically to non-exempts: training time. Essentially, any training that is required by the employer that the employee has to attend, that's basically going to be compensable time. So for example, if you have a lunch and learn, maybe there's a certification, maybe there's a CPR class, and they have to, continue to have that certification. If it's something that you as the employer are requiring that they attend, that is compensable time. Now, if an employee wants to go off on their own and further themselves and perhaps take some classes to get their own degree or get their own certification, and they're doing that on their own, and it's not required by the employer, that of course is what they're doing on their own, and that does not have to be paid for. But essentially that is something that the issue comes up for an employer is if, for example, there's an outside organization that just wants to come in and do a little bit of a presentation. You just need to make sure that you're not making that mandatory. That may be more of a benefit that's being provided, but it's not mandatory. Once you say you have to be there and you start, checking attendance, that transfers it into compensable time.
What about study time for mandatory certifications? Do we have to pay people to study?
That's a great question. And actually, it probably, again, as a lawyer, I'm going to tell you it depends. Yeah. But yes, I think a lot of employers do probably bank in some time for study time. I know, for example, I was just on a phone call with a client yesterday who was explaining to me that they have a very specific training regimen for their underwriters. And so their first and level underwriters, essentially they view that it's a non-exempt role, but they know that the folks are in that role because they have to get their certifications. And so as part of that workday, they build in time for them to study, and they build in time for them to take those certifications, because that really is the primary duty of that role, is to get prepared. And then once they get the then they're certified, then they're rolling up into an exempt position.
Yeah, and we'll talk about that again when it comes to, we're going to talk about independent contractors and the difference there with an independent contractor and what you have to do.
Absolutely. I'm going to just gloss over briefly meeting time. Essentially, that's the same concept as with training time. If you're requiring that an employee attend, then that becomes compensable work time, and they need to report that time. Home to work site travel in a company vehicle. I don't know if that's very specific to us, but there can be times that if in fact an employee has to travel in a company vehicle, there are some circumstances where that can mean that that's compensable work time. But I'm not going to get too much into the details on that for purposes of time. Pre and post shift activities. This may be something that does have some relevance for this particular group, and that can essentially relate to, I'm thinking of perhaps if there's uniforms that have to be worn in the healthcare setting. Essentially, if those folks if they're in their scrubs and they're getting dressed at home, that's not compensable time. If they've got freedom to, show up to work in their uniform, that's fine. If in fact it's a situation where the uniforms are being laundered on site and they have to arrive to work to be changed and ready to go for their shift time, that can potentially be a situation where that changes it into compensable time. And so again, that's sort of a case-by-case situation to look at that. Another example of pre-pro shift work that I could think of coming up in this instance would be in healthcare. If there's a mandatory shift meeting between shifts, where everybody reports, because there has to be that transition between shifts, that is actually compensable work time. So if their shift starts at 9 a.m., but they have to be there at 8:45 a.m. because they have to attend the shift meeting, that is compensable time. And again, just briefly in terms of minimum wage, in Georgia, minimum wage is $7.25. Whatever their hours work, they have to be paid that minimum. So looking forward in terms of salary basis, if you're not going to be paying them as exempts, you don't have to worry about paying them that $913 a week, but you do have to worry about the minimum wage for all hours. And then there's something on wage deductions. That essentially is if in fact you are requiring employees to come out of pocket for certain expenses. So for example, I had mentioned those uniforms. If they have to pay for those uniforms and it's not reimbursed, you basically just have to make sure that that expenditure does not take them below minimum wage. All right, so I'm going to just briefly, I had already mentioned this gets into math. Nobody likes to do math, but what you do need to know, nobody but the wage and hour lawyers like math. No, I don't like math either. What you need to know, if in fact you are paying people different rates of pay, so if you are paying them anything in addition to an hourly wage, or if you're paying them different hourly wages, you do need to basically count up all the compensation that they're getting in a week, and you need to divide it by the total hours worked, and that becomes, it's a term of art, it's called the regular rate. But for your purposes, that basically is the overtime rate. And that's the rate that you pay them time and a half. So if you're paying them a straight $10 an hour, that's easy, right? You know that their overtime rate, you're going to be paying time and a half, they're going to be getting $15 an hour. But if you also are paying them if you're paying them a shift differential, for example, if they get an additional 50 cents an hour for a shift differential, you have to add that up in. So that bumps your hourly rate up. It's not just the 10, it's the shift differential. If they have incentive payment that's based on their production, then you have to add that in. So again, I'm not going to go into more detail, but you do have to understand from an administrative and a bookkeeping standpoint, if you've got non-exempts that are being paid more than just the hourly wage, there's some math there.
But expense reimbursement is not included in
Correct.
that.
Correct.
So if you pay people for their expenses, for office supplies they go buy, or they drive for work and you pay for their gas, that isn't included. You don't have to include that.
Exactly. Any business expense is not includable. And you also don't have to include in vacation pay. So if you do have time off policies, you don't have to count those hours toward hours worked either. So if you're giving them paid time off and you're doing your overtime calculations for that week, that doesn't count toward the 40 hours.
Sick pay, vacation pay, holiday pay.
Exactly.
All of those. If they're not working, it doesn't count toward the 40.
Yep. All right, so we're going to, I know in terms of timing, our idea was try to wrap up the substantive part of our talk by 11, and I know we're bumping up on that, and to open it up for questions. The last sort of substantive piece that we're going to talk about here is the difference between independent contractors and employees, because I know those were some specific questions that we had received. So essentially, if in fact you are working with contractors, the issue of how you can treat them, because if in fact they're true contractors, so they're third-party vendors, and so the example I like to give would be, for example, all of those third parties that you contract for to do outside services. So your landscaping, your HVAC, your maintenance, all of those different parties that you have that are coming in to do work for you. Those are truly outside companies, right? They've got their own people, they've got their own employees. They're not on your payroll staff. So, for example, if you've got your maintenance workers that come in every night and do the cleaning and clean the bathrooms, they're not your employees, right? You don't have control over them. They're truly third parties. Sometimes employers will come in and they will want to contract with people to do work that is, similar to what they do. So, for example, if you're going to have a nurse that you're going to bring in to do some contract work, the question becomes, what's the tipping point? When does that nurse actually become an employee versus when are they truly an outside contractor and you don't have to worry, you don't have to care about what they're getting paid in their overtime. And it's a very complicated issue because, quite frankly, the IRS and the Department of Labor takes a very, very, very strict view of contractors. They really, truly want it to be that third party that's just very defined in terms of what they're coming in and doing for you. It becomes control. So if you have those nurses you're contracting with, and for example, if you've got specific educational requirements that you need them to come in and you need them to do training, and you're providing them with tools and you're setting their work, that's a big one. If you have control over their schedule and you're telling them when to report and when, those are one of the factors that can tip it toward an employee. And so we have one of the slides that lists the factors. The big one is degree of control, relative investment in terms of, are you providing them tools, or your landscapers, they've got their own tools, right? I mean, you don't have any outside investment in that. So that's one of the factors that's looked at. Profit and loss, how much as the employer are you dictating what they can earn? The permanency of the party's relationship. I typically say a year. If you've got a contractor that's technically, on your books for more than a year, then that starts to look at it like it's more of a permanent relationship. And then the services provided. If you've got contractors that are basically doing the exact same thing that your employees are doing, especially if they're long-term, that's something that may indicate that, in fact, they really in fact, are doing the work of an employee. And what does that mean to you as an employer? Basically, it means you have all the obligation of treating them, which means you have to make sure that they're reporting their time and they're getting overtime, etc. And there are other employment issues as well. Obviously, there's the joint employer issue, which we're not talking about today. We're just talking about wage and hour. But there, of course, are all sorts of other employment laws out there that would come into play. So, Valerie, did you have anything to add on that?
I was just thinking about some questions I've answered in the past, and one of them is, so let's say that you have a counselor who comes in periodically to meet with your clients. That might be, that's one that you could structure as an independent relationship, just because they probably work for other people. They don't just work for you. They they are it's not part of your core business, right? It's an extra thing that you provide. And even if you pay them a rate based on hours, you don't tell that counselor what to tell the person, right? You don't control the outcome. You are just making the you're setting it up. And then what the counselor and what that individual client talk about, that's really between the two of them. And so that's one of those that this is very fact specific. And so you can sometimes structure things one way or the other. But the real issue with independent contractors is you also give up control when you have an independent contractor. You can prescribe the results that you're looking for, but if you're talking about the process, like for example my counselor, no, don't tell them that, they'll get mad, then that's a lot more like an employee. Whereas if you say, well, it's unfortunate that they got mad, but that was up to your professional judgment about how you dealt with that client, that's more like an independent contractor. And a lot of times we want both, right? We want all the financial benefits that go with having an independent contractor, and yet we still want that control. And you have to let a little bit of control go. You can still control the quality to say your services are not up to par, just like you would for your landscaping service. You'd go outside and say, this is the worst result I have ever seen. Fix it or you're fired. You can still do that. But if you say, no, go over there, get that edge, that's more like an employee.
Absolutely. Well, that actually, I think, concludes our presentation. So I don't know if there were any questions.
We do have a couple of questions, and I would ask you to please repeat it into the microphone before you answer. The first question goes back to the professional exemption, and the question is, do LPCs or LCFWs qualify under professional or absolute?
Great. So the question is, under the learned professional, would and I'm not going to be able to repeat the actual acronyms, but basically, would counselors and social workers also qualify for the learned professional exemption? There are very specific rules in the regulations that talk about what will qualify. Social workers may qualify. They do have to have an advanced degree. So typically, we're looking at probably a master's of social work. And there probably are some state-specific certifications and requirements. Basically, it's going to come down to what level of education is required for that position, and many times there are state licensing requirements. In terms of the caseworkers, I don't know specifically. It really is going to depend on what we are requiring of the position, and we're going to be looking probably for a master's degree or a PhD and some additional certifications. But if that is in fact a requirement, and employers can run into problems with their job descriptions, because oftentimes we will say bachelor's degree preferred but not required, equivalent experience accepted. And if that's what you have on your job descriptions for your caseworkers or your social workers, that's not going to fly for the professional exemption. So it is very much incumbent upon the degree requirements. And you also have to put them in a position that requires them to rely on that. So for example, if you've got somebody who in a previous life was a lawyer, and obviously lawyers, if they are certified and they have their license and they went to law school, they're going to meet the professional exemption. But if you put them as a lawyer in a caseworker job, that's not going to fly. They have to have those requirements for that caseworker position. So you have to be very specific in terms of requiring that to be relied on.
I think you may have answered this one, but let's clarify it. In regard to the professional exemption, does that apply upon nurses or contractors?
The question is, will the professional exemption apply to nurses if in fact they're contractors? And the answer is yes. If they're meeting the certifications of being the registered nurses, they can be treated as exempt, but it's a different inquiry. Because the contractors we've just talked about, it's a different analysis as whether that nurse is being treated as a contractor or is treated as an employee. And so you really have two sets of analysis that you need to go through there.
So we have some centers that actually have paid nurses on staff that would take clients will come in during the daytime and do exams. Whereas at night, that's not really very much the contractor person. So like we mentioned earlier, the contractor person is doing the same type of work as they do, which in that case they would be. And the nurse during the daytime is also doing a lot of probably paperwork, keeping the files and things. But the contractor nurse is not going to do. But they still both are going to be doing during the daytime it would be the nurse with after 7 hours. Pay with a food, and then the contractor nurse is going to come in and do the exam, and then the handle of the files and the files. So is it okay leaving those two positions with a contracted professional and then fully professional?
We're gonna have to restate the question.
So the question was, if you have your nurses that come in during the day and typically do that work, you're treating them as employees, and then you might also have centers that have the same work being done in the evening as contracted for, but they maybe aren't doing some of the additional work done in the day, so maybe some of the administrative work, etc. And the question is, can you treat the daytime folks as employees and the nighttime as contractors? And unfortunately, the answer is going to be it depends. I think we're really going to have to know more information about that because, as I said, the contractor analysis is very specific. We only talked about 5 or 6 factors. There's actually, I think, a total of 17 factors, depending on what test. So the answer is we might be able to, but what we're really going to have to look at is the degree of control. Primarily, is that person still coming in? Is it working 40 hours a week? Is it a day in, day out type of situation, or not? And so the answer is we may be able to treat them still as contractors, but we're just going to have to look at the specifics of the situation.
And the other thing is, just like with the counselor who comes in, or there are ways that you can structure the relationship. So if you ask the question, it may be that you can say, all right, well, we're willing to give up this level of control in order to have this be a contractor relationship. And so let's do these. Well, let's make it clear that we're only expecting the deliverable, the results of the physical. That person can spend as much time or as little time with the client as they want, just those kinds of things that go to those 17 factors. And so if you ask the question, sometimes you can structure the relationship the way so it remains an independent contractor, because you can affect things by how you retain somebody, and so that, and how you set the expectations of what the actual deliverable in the relationship is. So I just ask the question. Part of this is becoming aware of the fact that there are questions you need to ask. Absolutely. Don't just keep your head in the sand, because that way lies trouble.
Our next question relates to on-call time. The question is, can you pay a non-exempt 40-hour employee $2 an hour standby when they're on call after their 8-hour workday, and then time and a half if they're called in?
Yes, as an additional incentive. I'm sorry. Okay, so the question is, can you essentially pay employees that are on call, can you pay them essentially a $2 stipend for the time they're on call? And then pay them their normal time and a half, their normal hourly rate at time and a half for when they're called in. The question, just to clarify, are you saying it would be $2 for every hour that they're on call? And you may not know the answer. I'll just assume that that's.
I think you can assume that that's the case.
Yes. So essentially, you can pay folks additional money basically for incentive for on-call time. And in fact, if they're not actually doing any work during that time, you don't even have to include that in your overtime rate calculations. So yes, absolutely. If that's being treated as an incentive to get them to take the on-call duty, you can absolutely do that. And it just becomes they need to record the time that they're working when they actually do get called in and count that toward overtime.
Okay, if that was our last question, thank everybody so much for your attendance and engagement and participation. And got anything else you wanted to say?
I don't. Thanks very much and good luck.